My uncle walked into the probate hearing and told the judge I was no one's daughter. He said it in the steady, factual tone of a man making a correction, not angrily, not cruelly, simply clearly, the way you state something you consider self-evident. He said it in front of the court reporter and the gallery and me. He had his attorney beside him and a 12-page brief and the confidence of a person who has never seriously entertained the possibility of being wrong. He was 36 years too late. My father had already answered him on a Tuesday morning in March in the year I was 11 months old at the Spokane County Auditor's Office on West Riverside Avenue. The answer had been sitting in the public record ever since, properly filed and properly stamped and waiting for exactly this question. Good day, dear listeners. It's Lena again, and I'm so glad you're here with me today. Before we begin, please take a moment to subscribe to the channel and tap the like button. It helps these stories reach the people who need them. And tell me in the comments which city you're listening from. I love seeing just how far these stories travel. Identity, it turns out, is not only a feeling, it is also a document. The people who love us most understand that the two things are not in contradiction, that you can sign your name to something with your full heart and your full attention, and that the signature does not diminish the love or qualify it or reduce it to something merely contractual. It makes the love legible. It makes the love survivable past the span of one person's presence in the world. Feelings exist inside the person who holds them, and when that person is gone, the feelings go with them. But the document remains. It remains in the county auditor's system, in the public record, properly filed, properly stamped, available to anyone who knows to look. My father understood this without being told. He filed the declaration when I was 11 months old, signed it, had it notarized, filed it with the Spokane County Auditor's Office, and then he never brought it up again. Not because he had forgotten it, because in his understanding, the truth had been documented, and documented truths do not require supplementary narration. They wait in the record. They wait for as long as they need to wait. They answer the question when the question finally arrives. I am Ida Voss. I am 37 years old. I work in Spokane, Washington as a licensed clinical social worker. I specialize in adolescents, in foster care and transitional housing, young people who are, in many cases, required to document themselves, to prove their identities and their histories, to establish their legal standing within bureaucratic structures that were not built with generosity toward anyone who arrives without the right paperwork. I chose this work deliberately. I chose it knowing my own history, knowing that I understood something about what it means to need someone to have filed the right form in the right place at the right time, so that when the question comes, and the question always comes, in one form or another, in one venue or another, there is an answer that cannot be contested. I grew up knowing that my father was Emil Voss. I grew up knowing it in the particular, unexamined way that children know things that have been true since before they were old enough to question them. Emil and I were close in the way that quiet people are close, not through performance or declaration, but through accumulation. Through the weekly phone calls that he initiated at 7 on Sunday evenings, with the same regularity that he brought to every other scheduled activity in his life. Through the shared crosswords, he would mail me the puzzle filled in to the halfway point, and I would complete the second half and mail it back. And we would compare our approaches over the phone the following Sunday. Through the dinners every second week, at the small table in his apartment that looked out at the river bend, where we cooked something together and talked about our weeks, and did not feel the need to announce that we were enjoying each other's company, because the enjoyment was simply there and had always been. Emil never married. He built his certified public accounting practice in Spokane over 4 decades, starting from a single rented desk in a shared office building on the south side of the city, 2 clients, a second-hand adding machine, and the systematic patience of a man who understood that the foundation of a practice, like the foundation of any reliable thing, is built by doing the work correctly, one client at a time, without shortcuts. He kept meticulous records from the beginning, not because anyone required him to, but because accurate records were the foundation of every sound thing, and he did not build unsound things. His first client was a family-owned hardware store on the south side of the city, a father and 2 adult sons who had been doing their books by hand and had reached a scale where that was no longer adequate. Emil spent 2 evenings a week at the hardware store for the first 3 months, learning the business before he touched the numbers, because he believed you could not account for something you did not understand. He kept that client for 31 years, until the father died and the son sold the business, and the accounting relationship transferred to the new owner, who kept Emil for 7 more years afterward, because Emil's reputation had become attached to the word reliable in a way that was hard to dislodge. He grew the practice slowly and on purpose. A second client in the 4th month, a dentist's practice on the north side who had been referred by a colleague and who stayed for 24 years. A third client the following year. By the 5th year, he had outgrown the rented desk and signed a lease on a single-room office of his own, with a window that looked sideways at the river if you stood at the right angle. By the 10th year, he had a second associate and a small conference room. By the 20th year, he had the 5th floor suite and the view of the river bend that he would keep for the rest of his working life. He did not advertise. He did not join civic organizations for the purpose of client development. He did not attend networking events. His clients came from his clients from the hardware store. Son who mentioned him to the dentist's sister-in-law from the dentist who mentioned him to the restaurant owner 3 blocks south, from the restaurant owner who mentioned him to the small manufacturer who became one of his largest accounts. Emil understood that a practice built on referral is a practice built on trust, and trust is earned by doing the work correctly. 1 tax season and 1 quarterly estimate, and 1 properly filed document at a time, without exception and without shortcuts. He had been doing it that way for 40 years when he died, and the practice was sound, and the records were in order, and every document was filed in the appropriate place. By the end, he had a suite on the 5th floor of a building that looked over the river with 3 associates, a billing coordinator, and a paralegal office manager named Constance Rio, who had been with him for 22 years. Constance Rio is 64 years old, and she had been the professional center of Emil's practice for more than 2 decades. I have known her since I was a teenager. She was already Emil's office manager by the time I was old enough to understand what that meant, and she has always regarded me with the specific warmth of someone who watched a child grow up at close range without being the child's parent, the warmth of a witness. Constance had started at the practice 22 years earlier as a billing coordinator, a role she had taken after leaving a position at a larger regional firm where, as she put it once, the filing was excellent, but no one remembered why they were filing. At Emil's practice, the why was always clear. She had been promoted to office manager in her 4th year and to paralegal office manager, a title she had designed herself because it more accurately described the function she was actually performing in her 7th. In the years since, she had managed the practice's operational infrastructure with the same systematic attention that Emil brought to client accounts. Nothing out of place, nothing past its deadline, nothing filed in the wrong location. She knew where every document was. She knew when every document had been created, and by whom and under what circumstances and what it was for. She knew the trust documents, the client engagement letters, the tax elections, the entity filings, the annual updates. She knew the voluntary parentage declaration because she had been the one to find it, not in Emil's private files, but in the county auditor's public records, which she had reviewed as part of an estate planning audit she ran on Emil's affairs every 5 years, because someone had to, and Emil was too modest to do it for himself. She had found it on a Tuesday afternoon and had looked at it for a long time before she called me. She knows Emil's professional habits the way you know something you have studied for 20 years. Not just the facts of them, but the reasons behind them, the logic that produced them, the way each habit connects to the others. This knowledge would turn out to matter enormously. Emil updated his revocable trust 3 times in the last decade of his life. At 59, at 64, and 4 months before his death, when he came in to see Constance and made a set of final amendments that she described to me afterward as clear, specific, and unremarkable, which is high praise in the context of estate documents, because unremarkable means there is nothing there to contest. He named me as sole heir in every version of the trust. The estate at the time of his death consisted of the rental duplex in the University District, the brokerage account totaling $186,000, and certain personal property. The combined value was $318,000. He had been building this quietly for 40 years, one client and one tax season and one careful investment at a time, and he had named me in it every time he updated the document. Have you ever thought you were prepared for the administrative work of grief, and then discovered that the preparing and the living are 2 entirely different conditions? I thought the morning after Emil's funeral that the hard part was done. He had organized everything. Constance had the files. The trust was clear. I knew what needed to be done. I was wrong about how settled the situation was. Glenn Voss is my father's half-brother. Different mothers, same father. A man who had died before I was born and whose existence in Emil's early life had been complicated in the particular ways that complicated fathers complicate things. Glenn and Emil were not estranged. Their relationship was functional and distant. Christmas cards, occasional phone calls, one visit in the last decade, a Saturday afternoon in Kennewick that had apparently been civil without being warm. Glenn retired from a career as an insurance adjuster. He lives in Kennewick with his wife, Maura. In 37 years of my knowing that Glenn Voss existed as a fact in my father's family, he had never addressed me directly. He had not been at the funeral. He had sent a card. He called me 6 days after the funeral. The call came in the early evening. Glenn said he was calling to offer his condolences. He offered them in the manner of a man discharging a necessary formality, briefly, without particularity, with the right words, but without the weight of genuine feeling behind them. Then, in the same measured tone, without transition, he asked whether Emile had ever mentioned the family situation. I did not know what he meant. I told him so. He said he was sure we would be in touch. He was correct. Constance had called me 4 days after the funeral, before Glenn's call, because she had noticed something before I had. She said, "Your uncle has retained counsel. I think you should come in." She paused and added, "I think you might already have what we need to discuss, but come in anyway." Her voice had the quality of focused urgency without alarm, the quality of someone who has identified a specific problem and has already begun organizing toward the solution. Glenn's attorney had filed a notice with the probate court within 2 weeks of my father's death, not the standard timeline. Probate proceedings have their own rhythm, and that rhythm involves waiting for the estate to be formally submitted before anyone challenges it. Glenn's attorney had filed before I had been formally notified by the court, before the standard waiting period had elapsed. Constance noticed this because she monitored probate court filings that touched her clients' estates, and the filing had appeared faster than anything should have appeared. The formal letter from Glenn's attorney arrived the following week. It stated in careful legal language that Ida Voss's parentage of Emile Voss was legally unverified. It cited the absence of a marriage. It noted the absence of a formal adoption. It noted the absence of a court-ordered paternity determination. It cited Washington Revised Code 11.04.015 and argued that without documented legal parentage, I had no standing as a natural child, and therefore no standing as Emile's heir. It requested a continuance to permit posthumous DNA testing, complicated, contested, time-consuming, but argued to be the appropriate mechanism. The letter also identified Glenn Voss as the only blood relative of Emile Voss and stated that in the absence of my established standing, Glenn was the rightful heir. I read the letter at my kitchen desk. Emile's reading glasses were on the left side of the desk, where I had placed them after the funeral. He had left them at my kitchen table 2 weeks before his death, had set them down beside the crossword we were working through, and forgotten them when he left, which was unlike him. I looked at the reading glasses. I thought about 40 years of Sunday calls. I thought about $318,000. I called Constance. At the probate hearing, a Tuesday morning at the Spokane County Courthouse, Family Court Division, Glenn arrived with his attorney and Maura. Maura sat in the gallery, second row, with a small planner on her knee. She made a note at some point during the proceedings that I could see but not read from where I sat. Glenn's attorney presented his argument methodically. He cited the statute. He walked the court through the absence of documentary evidence for my legal relationship to Emile Voss. He characterized my standing as legally unverified. He said that in the absence of a marriage certificate, an adoption record, a court order, or a DNA test, Ida Voss had no standing as a natural heir, and that Glenn Voss, as the documented blood relative, was the appropriate party to inherit. Then Glenn spoke directly to Judge Patricia Odom. He had decided that his own voice, his own direct address to the judge, would carry more persuasive weight than additional attorney argument. He said Emil was a good man. He said he was not there to speak ill of his brother. He said, "This woman," and he gestured toward me in the third person while I sat 6 feet away from him, while I was looking directly at him. This woman was raised largely by her mother's family. Emil never formally established any legal relationship with her. There is no record of it. She has no standing here. I was sitting 6 feet away. I heard every word. Have you ever been described in the third person in a room where you were physically present? There is a specific quality to the experience of being spoken about, as though you were absent, as though your presence in the room did not itself constitute a counter-argument to the premise being stated. I felt my hands on the table. I felt the chair back. I felt the document in my attorney's folder. I did not change my expression. Judge Patricia Odom had a copy of the Voluntary Parentage Declaration in front of her. My attorney, Douglas Fender, had placed it on the bench before Glenn's attorney had finished his main argument. Placed it quietly, without theater. The way you place something when you know it will do the work without your help. She was reading it while Glenn was speaking. My attorney asked for a brief recess. In the courthouse hallway, he told me that Glenn's argument was legally incoherent given the document we had produced, but that without the document, our position would have required an extended and costly legal process. He said, "You've been carrying this for 6 years." I said, "Constance told me to carry it." He said, "I need to remember to thank Constance." Then he straightened his jacket, and we walked back in. Constance Rio was in the gallery. She had come without being asked, had taken the morning off from the office, and driven to the courthouse, and was seated in the 3rd row in her good gray coat, watching with the focused attention of someone who had been involved with matters adjacent to this one for more than 2 decades, and who intended to see it resolved correctly. She gave me a single small nod when I walked back in. Judge Odom read the relevant portion of RC Bo 26-26-300 into the record. She read it in the matter-of-fact way that efficient judges handle clear cases without editorial commentary, simply placing the applicable law in the transcript. A voluntary parentage declaration properly filed with the county auditor carries the same legal force as a court judgment of paternity. Not a lesser force, not a contingent one, the same force. My father had filed this document 36 years ago, and it had been in the public record ever since, and the standing it established was legal fact. Glenn's attorney began a sentence about a continuance for further review. She let him finish it. Then she addressed the matter briefly. And finally, the continuance was denied. The matter was closed. I want to tell you about the specific quality of the courthouse hallway during the recess, because it matters to the story. The hallway had tall windows that looked out over the street, and the March light came through at an angle that made everything in the corridor appear in careful relief. I stood with Douglas Fender near one of the windows, and he told me, carefully, what the options were in the absence of the document. Posthumous DNA testing, contested and slow. likely successful but time-consuming and emotionally difficult. He said likely, and he meant it, and he also meant that likely is not certain. I listened with the part of my mind that processes information and sorts it into categories of action. The other part of my mind was somewhere else entirely. Before that, I was thinking about the 6 years I had been carrying the document. Constance had given it to me on an afternoon in February, 6 years before the hearing. She had called me at the end of the workday and said, "Ida, can you come in tomorrow morning before your first appointment?" She had not said why. When I arrived, she had the certified copy on the desk in front of her, face down, and had asked me to sit before she turned it over. She had said, "I found this in the county records when I was doing a routine audit of your father's estate planning materials. You need to know it exists. You need to have a copy." She had turned it over. I had read it. I had read it again. I had understood what I was looking at. I had worked in enough documentation-dependent contexts to understand the statutory weight of a properly filed voluntary parentage declaration under Washington law. And I had sat with that understanding for a long moment without speaking. Constance had not filled the silence. She is not a person who fills silences unnecessarily. I had said, "He never mentioned this." She had said, "No, he wouldn't have." It was filed. It was in order. She had slid an envelope across the desk. The certified copy was inside. She had said, "Carry this." Not in the fireproof box. Carry it. I had taken the envelope. I'd carried it in the accordion folder for 6 years, the folder I brought to court. The folder that was already on the table when Douglas Fender placed the copy on the judge's bench. I was thinking about the last Sunday dinner at Emil's apartment. 2 weeks before he died. We had made pasta, his recipe, learned from a client who had given him the method years ago and that he had made reliably ever since. We had eaten at the small table that looked out at the river. He had set down his fork at one point and looked at something in the middle distance for a long moment, the way he occasionally did when he was thinking about something he had not decided whether to say. Then he had picked up his fork and returned to the pasta and said nothing, and I had returned to mine. And we had finished dinner and worked the crossword together, and I had driven home at 9. I have thought about that moment of silence many times since. I have wondered what he was considering. I have wondered whether he was thinking about the filing, whether he had thought then about saying, "Ida, there is a document in the county records. A voluntary parentage declaration I filed 36 years ago in case you ever need it." I believe he considered saying it. I believe he decided against it because it had already been filed, and the filing was the important thing. And filed things do not require supplementary narration. They simply wait in the record. And he trusted the record. I had called Constance from the hallway. She had answered immediately, which meant she had been waiting. She said, "The filing. Your father filed a voluntary parentage declaration when you were 11 months old. RCW 2626A 300. It's in the county records. I have a certified copy." I said, "I have one too." She was quiet for a moment. In that quiet, I heard the particular relief of someone who has been holding something carefully for a long time and can finally set it down. She said, "I know. I gave it to you 6 years ago. Now go use it." The document I had been carrying for 6 years. Emil Rolf Voss. Voluntary Parentage Declaration, executed pursuant to Washington Revised Code 26.6000. acknowledging parentage of Ida Marie Voss, born on the stated date, to her mother. Emil Voss declaring himself voluntarily to be the father and accepting all legal rights and responsibilities attendant to that declaration. Signed in the presence of a licensed notary public. The notary seal present and clear. The Spokane County Auditor's filing stamp present, dated March 3rd, 36 years before the probate hearing. The box labeled Voluntary Acknowledgement of Parentage checked by my father's hand. His signature there, the signature of a 35-year-old man, slightly more careful than the signature I recognized from the later years, the handwriting of someone giving a document his full attention, his particular way of beginning the capital E in Emil, his way of crossing the T in Voss, unmistakably his signature, unmistakably his name, unmistakably his declaration. Under Washington Revised Code 2626-300, a voluntary parentage declaration properly filed with the county auditor carries the same legal force as a court judgment of paternity. The same force. Not provisional, not contingent. The same weight as a judicial order. My father had understood this when he filed it. He was a CPA. He read statutes carefully. He understood the legal significance of a properly executed and properly filed document, and he had filed the declaration on March 3rd of the year I was 11 months old, and it had been in the public record ever since, and it had established my standing as his natural child from the date of the filing forward. Douglas Fender placed the document on the judge's bench before Glenn's attorney had completed his main argument. He placed it quietly, without announcement or theater. The way you place something you know will resolve the matter without assistance. Judge Odom read it while Glenn was speaking. She read the applicable statute while Glenn's attorney was constructing his conclusion. She read the filing stamp. She read the notary seal. She read the box that was checked. She read my father's signature. Then she read the statute into the record, and the matter was closed. After the hearing, Constance told me what Emil had said when she first found the filing in his records and told him she had seen it. He had been sitting at his desk reviewing a client's quarterly estimated payment schedule. He had looked up when she said what she had found. He had said, "Good. It should be in order." He had returned to the estimated payment schedule. Constance had said, "Emil, I think Ida should know this exists." He had considered this for a moment. Then he had said, "Yes, I suppose she should." And Constance had called me that afternoon. He had not said, "I filed it for her protection." He had not said, "I wanted to make sure she was taken care of." He had said it should be in order. Because it was simply correct that it should be in order. And in order things were filed in the appropriate place. And the appropriate place for a voluntary parentage declaration was the county auditor's office. And he had filed it there 36 years ago. And the matter had been settled ever since, in his understanding. And there was nothing more to say about it. I thought about this for a long time after the hearing. Not with particular emotion, with the specific quality of attention I bring to things that I want to understand correctly. My father had been 35 years old when he filed the declaration. He had been building his practice. He had 2 clients and a rented desk and a secondhand adding machine and the patience of someone who understands that reliable things are built one correct action at a time. He had filed the voluntary parentage declaration with the same methodical attention he brought to client filings and quarterly estimates and tax season deadlines. He had filed it because it was true, and true things belong in the record, and the record is where they wait. He had waited 36 years for the record to matter. He had not known, when he filed it, that it would take 36 years. He had not known whether it would ever need to matter. He had filed it because the filing was correct, and correct things are done regardless of whether their utility is immediately apparent, and he had trusted the record to do its work whenever its work was needed. After the hearing, I administered the estate. This is the part of the story that does not make for dramatic narration, which is perhaps why it is also the part that most clearly reveals the nature of the man I had lost. Administering an estate is documentation work, a succession of filings and confirmations and tax elections and property transfers and correspondence with financial institutions. The duplex required attention immediately, a deferred maintenance issue in the lower unit, an aging water heater, and a slow kitchen leak that had been managed but not repaired. I engaged a licensed plumber and a property management firm within the first month. I negotiated new lease terms with both tenants and arranged a comprehensive maintenance inspection of both units. The duplex was generating reliable rental income, and I intended to keep it generating reliable rental income because that was what Emile had built it to do, and that is what it was good at. The brokerage account transfer was standard. The trust documents, the death certificate, the beneficiary documentation, the financial institution's estate department, handled in the second month. The personal property distribution followed Emile's instructions. Between the duplex maintenance and the brokerage transfer, I spent approximately 12 weeks in close administrative proximity to Emile's professional life, reviewing files, corresponding with institutions, processing the succession of paperwork that an estate generates. I had done similar documentation work in my own professional practice, guiding adolescents through the paperwork that the foster system requires, identifying documents, enrollment verification, housing applications, benefit eligibility forms. I was not unfamiliar with bureaucratic machinery, but there is a difference between understanding documentation work and doing it for the estate of the man who taught you, by example, what it meant to do that work with care. I went through Emile's professional files over the first 3 weeks. Constance had organized them, which meant they were organized the way that Constance organized things, not only clearly but logically, in a system that reflected the relationships between documents rather than simply their chronological order. Client files were arranged by engagement type and then by client, with cross-references noting which filings connected to which other filings. Administrative files were organized by year and category. The trust documents were in a dedicated section, the 3 versions, in order, with annotations noting what had changed between each update and why. I found no document I had not expected to find. Emile had been a man who did not keep things for no reason and did not discard things prematurely. The files contained what the files should contain and were in the order they should be in. I noted this with the specific relief of someone who had been braced for disorder and found instead the familiar architecture of her father's professional mind. The duplex required 2 contractor visits in the first month. The plumber for the water heater and the kitchen leak, and a general contractor for a deferred maintenance list that the property management firm had assembled during the inspection. The water heater was replaced, the kitchen leak was repaired, and the surrounding drywall assessed no structural damage, which was the better of the two possible findings. The property management firm engaged both tenants on the new lease terms and administered the maintenance schedule going forward. By the end of month 2, the duplex was generating the reliable rental income that Emil had been generating from it for the past 9 years and would continue to generate it, and that was what the property was for. Certain books to the Spokane Public Library system, certain professional materials to his 3 associates, personal effects to me. I kept the reading glasses on the left side of my desk beside the lamp. They are the reading glasses of a man who left them at my kitchen table and did not come back for them. They catch the morning light sometimes before the lamp is on, in a thin brightness that is cool and specific, and has no particular resonance I can name except that it is there every morning. And I notice it. Glenn did not file any further objections during the administration period. He was quiet. He drove back to Kennewick after the hearing, and I did not hear from him for a year and a half. During those months, I sometimes thought about what the hearing had been from his perspective. The drive from Kennewick, the attorney, the 12-page brief, the direct address to the judge, and then 4 minutes of reading by Judge Odom that closed the entire matter before lunch. I did not think about this with any particular satisfaction. I thought about it with something more neutral, a recognition that someone had done a great deal of preparation for an outcome that the public record had already determined 36 years earlier and had simply not been consulted about. Constance told me several weeks after the hearing about the reconnaissance call. 2 years before Emil's death, Glenn had called the office on a Tuesday morning. He had called the front line, not Emil's direct extension, which meant he had gone through reception rather than calling Emil himself. He had asked Constance whether Emil had gotten around to updating his paperwork. He had not specified which paperwork. He had not said what he expected to find. He had asked in a tone that Constance recognized as more purposeful than casual whether Emil had updated anything recently. Constance had said she was not in a position to discuss client files. Glenn had said he understood and thanked her for her time. She had told Emil about the call that same afternoon. Emil had said, "Thank you for handling that correctly." He had gone back to the document he was reviewing. He had not mentioned Glenn again in Constance's presence in the 2 years between that call and his death. But 4 months before his death, he had come in and updated the trust for the 3rd time. The amendments were clear, specific, and unremarkable. He had named me as sole heir, as he had always named me, and he had signed the document and returned it to Constance, and driven home to have dinner and work the crossword. Glenn had made his reconnaissance 2 years in advance. He had learned nothing. He had waited. He had filed his objection within 2 weeks of the death, faster than the standard timeline, faster than I had been formally notified, and he had arrived at the hearing with his 12-page brief and 36 years of accumulated certainty that my relationship to Emil was legally undocumented. He had been wrong for 36 years. He had simply never thought to check the county records. Or perhaps he had thought to check them and had not known what he was looking for. The county auditor maintains a searchable index. Anyone can search it. The voluntary parentage declaration was filed under Emil Voss's name, and under my name, and under the filing category that the auditor's system uses for parentage declarations, a category that exists alongside marriage records and deed records, and the other instruments that establish legal relationships between people. It was findable. It had always been findable. The insurance adjuster's mind looks for the gap, and Glenn had found what he thought was the gap: the absence of a marriage, the absence of a court order, the absence of a formal adoption, and had not looked further. My father had known that a gap could appear in those places. He had known it at 35 before Glenn had thought to look for it, before I had been alive long enough to need anyone to look for it. He had filed the voluntary parentage declaration not to fill a gap that had already been identified, but because he was the kind of person who identified gaps before they became problems and filed the correct document in the correct place before the problem materialized. He had done it with client filings for 40 years. He had done it for me on a Tuesday morning in March when I was 11 months old. And he had trusted the record to hold, and the record had held. The insurance adjuster's mind looks for the gap, for the unverified claim, for the place where the documentation breaks down and the assertion stands alone. He had looked for that gap in my relationship to Emil and believed he had found it. He had not found it. The gap was not there. My father had closed the gap on a Tuesday morning in March, 36 years before the hearing, with a voluntary acknowledgement of parentage and a filing fee, and the box checked with his own hand. I administered the first month of rental income from the duplex into the Transitional Housing Stipend Fund. 3 adolescents on my current caseload were aging out of the foster system, facing the specific financial cliff that aging out creates, the point at which state support ends and personal resources must begin. Resources that were, in each case, insufficient to bridge the gap without assistance. I funded 3 months of transitional housing stipends for each of them. Emil had spent 40 years helping people manage their money, accurately and carefully. The 3 adolescents on my caseload that quarter were 17, 17, and 18 years old. All 3 were within months of aging out of the foster system, the administrative moment that the system treats as a graduation, but that is, in practical terms, a cliff. State support has a cutoff date. The cutoff date is a date on a calendar, and the calendar does not consult the adolescent's readiness or their employment situation or their housing stability or their access to the deposit that most landlords require before a lease is signed. It consults the date, and the date arrives, and the support ends. I had been working for several months to identify transitional housing placements for all 3. 1 placement was confirmed. 2 were not for lack of trying, but for lack of the bridge funding that allows a confirmed placement to become an actual placement, because confirmed placements require first and last month's rent and a security deposit, and state support does not cover the deposit, and the adolescent aging out of foster care at 17 or 18 does not typically have the deposit saved from resources they have not had. I funded 3 months of transitional housing stipends for each of them. I did it through the established nonprofit fund that I had been directing client families to for 3 years, a fund with accountability mechanisms and expenditure documentation and quarterly audits, because Emil's money was going to be handled correctly or not at all. 2 of the 3 placements were confirmed within the month. The third took 6 more weeks, and a different housing provider. All 3 were housed before my caseload quarter closed. I am not recounting this for any purpose other than accuracy. Emil built the estate one correct action at a time over 40 years. I administered it one correct action at a time over 12 weeks. Some of the actions were paperwork, some were plumbing, some were housing stipends for adolescents who had no one who had filed the right document at the right time when they were 11 months old. Not all of them had that. Emil had given it to me. I tried to give something equivalent in my own form and within my own capacity to the 3 people in my caseload who needed it most. I spent his money accurately and carefully in the direction it seemed most right to go. The final distribution of the estate was processed in week 12 of administration. Douglas Fender called me on a Tuesday morning to confirm that the transfer was complete and the estate of Emil Rolf Voss was closed. He said, "Your father prepared well." I said, "He always did." He said, "The voluntary parentage declaration was 36 years old. He filed it the same year he opened his 3rd client account." I looked it up. I said, he was building the practice at the same time. He was building everything at the same time. Douglas was quiet for a moment. He said, "That is a certain kind of person." I said, "Yes, it is." 18 months after the hearing, Glenn called me. It was an evening call, uncertain in the way that people are uncertain when they have been working up to something for a long time. He asked whether Emil had left anything in his files that mentioned their shared father, the man who had died before I was born, whose complicated presence in both their early histories had never been openly discussed in my presence. I said I would look. I went through Emil's secondary files carefully. I did not find anything specifically about their father. I am not entirely certain I looked with the fullest possible thoroughness. There are excavations that do not belong to me, and I've never been certain that Glenn's relationship to that history is something I am equipped to address on Emil's behalf. The moment I think about most precisely is the parking lot. I was watching through the tall courthouse windows when Glenn and Maura emerged from the building after the hearing. Glenn walked to his car, a dark sedan, parked near the far end of the lot, and reached for the driver's door handle, and then stopped. He stood with his hand on the door and his other hand resting on the roof of the car, and he did not get in. He stood there for what I estimated to be close to a full minute, though it may have been less. Time moves differently when you are watching someone go still in the middle of an intended action. He was not looking at anything in particular. He was looking at the parking lot or at the ground or at something in his own mind that I could not see through the courthouse glass. I thought about what the morning had been for him. He had driven from Kennewick. He had retained an attorney. He had prepared a 12-page brief. He had stood in a probate hearing and stated to a judge, clearly and directly and in a public proceeding that was being transcribed by a court reporter, that Ida Voss was legally no one's daughter. He had said it in front of the gallery. He had said it in front of me. And the judge had read a 36-year-old filing from the Spokane County Auditor's Office and closed the matter before lunch. Glenn got into the car. Maura got in on the passenger side. They drove south toward Kennewick and were gone. Constance Rio was standing beside me at the courthouse window. She had been with me for most of the morning. She said, "Your father knew this day might come. He filed that document on purpose. Emile was not a man who did things by accident." She said it with the certainty of someone who had worked alongside a man for 22 years and understood his intentions as well as she understood her own filing system. Completely. I said, "I know." She said, "He filed it the year you were 11 months old." He was 35 years old. He was building the practice from 2 clients and a rented desk, and he walked into the county auditor's office and filed a voluntary parentage declaration because you were his daughter and the record needed to say so. She paused. He would have been very pleased with this morning. I thought about Emile at 35 walking into the county auditor's office on that Tuesday in March, the document in hand, the notary seal to come, the box to be checked. His signature on the declaration line, careful and deliberate. The signature of a man who understood that what he was signing was important and was giving it his full attention. The stamp coming down on the paper. The record made. He had done it for one reason. Because I was his daughter, and the record needed to say so, in a form that would be accessible to anyone who needed to access it, regardless of what anyone subsequently believed or argued or decided to contest. He had been 35 years old. He had not known that Glenn would drive from Kennewick 36 years later with a 12-page brief. He had not needed to know. He had filed what needed to be filed, in the place where it needed to be filed, and trusted the record to do the work. The record did the work. The estate closed in week 12 of administration. The duplex was generating reliable income. The brokerage account was transferred and repositioned with the assistance of the financial advisor Emile had used for 15 years. The personal property was distributed according to his instructions. Every document was filed in the appropriate place, labeled correctly, stored in the fireproof box, Emile's fireproof box, which I had taken from his apartment after the funeral, because it was a good box, and it had served him well, and it would serve me well. I kept the reading glasses on the left side of my desk, beside the lamp, where they catch the morning light before the lamp is on. I kept the crosswords, the stack of the ones he had mailed me half-finished, the ones I had mailed back. I kept the trust documents in the fireproof box. I kept the certified copy of the voluntary parentage declaration in the accordion folder in my desk at the office beside my professional license, where Constance had told me to carry it 6 years ago. Glenn called 18 months after the hearing to ask about their father. I looked through Emile's files. I was not certain I had looked everywhere. The call ended without resolution. I have not heard from Glenn since. The matter was resolved in the courtroom. The record is clear. Constance sends me a Christmas card every year. The fireproof box sits in the closet of my home office. I reorganized its contents after the estate closed, took out Emile's documents, replaced them with mine. My will, which I had updated 2 months after the hearing, my trust documents, my beneficiary designations for the retirement accounts, my power of attorney, the certified copy of the voluntary parentage declaration, which I had taken from the accordion folder after the estate closed, because the accordion folder was for active documents, and the declaration had served its active purpose and could now be kept in the fireproof box with the rest of the settled matters. The accordion folder now holds the current professional materials, the documents I need to carry, my clinical license, the current client engagement materials, the institutional forms for the Transitional Housing Fund, things I am actively using. The accordion folder is for active documents. The fireproof box is for settled ones. Emile taught me this distinction without ever stating it as a principle, simply by practicing it consistently for 40 years in my observation. It arrives on the same date each December, which is a specifically Constance thing to do, and I have come to rely on it in the way you rely on things that arrive when they say they will. Your father can love you without announcement, without declaration, without ever once mentioning the voluntary parentage declaration he filed with the county auditor when you were 11 months old. He can love you in weekly phone calls and shared crosswords and second Sunday dinners and everything is in order. He can love you in all of that and still understand that some loves need to be filed, need to be stamped and numbered and placed in the public record, where anyone who needs to access them can access them for as long as the records are maintained. Some people leave you money. Some people leave you the proof that you were theirs. Emile Rolf Voss, CPA, Spokane, Washington, left both, and he left the second one 36 years before anyone required it, because he was a man who filed things correctly and on time and did not wait for the occasion to make the filing obvious. He filed it because it was true. The record said what was true. That was sufficient. If you have ever needed a document to prove a truth that everyone who mattered already knew, tell me in the comments. Tell me where you are listening from. Tell me whether the document was there when you needed it, or whether someone had the foresight to put it in the right place before you knew you would need it. I want to know how far these stories travel. Thank you for being here. Stay with Lena. We have more of these.